Okay.
Ecuadorian citizenship withdrawal, asylum status withdrawal, potential extradition. Are these measures in compliance with current international law?
Ecuador has violated not only international law, has violated Ecuadorian law and Ecuadorian constitutional provisions. Fact is, you don't have to give someone asylum. But once you give someone asylum, this is a sacrosanct principle of international law. And you cannot strip someone of asylum without very, very weighty reasons. The international, or rather the Inter-American Court of Human Rights already last year warned Ecuador not to do it because it would entail a violation of international law. Ecuador did it nonetheless. Why? They created fake news. They created a false image of Assange and tried to say that his behavior was such that was incompatible with the status of being someone enjoying refugee status or asylum status. So this is basically a farce, but Ecuador now has a government that is essentially not a democratic government because he was elected on a platform to do certain things, and he's done a 180-degree turnabout. So he's essentially pursuing a policy for which he was not elected. And he has committed such grave violations of the Ecuadorian constitution. So here the problem is that Ecuador is a relatively poor country under enormous pressure from the United States. The United States wants to get hold of Assange and Ecuador buckled down. Now, that should be before the Inter-American Court of Human Rights again. And I think lawyers would be well advised to submit the case to the Inter-American Court of Human Rights. On the other hand, whatever happens in the British courts, now we know that the Home Secretary has actually signed the extradition order. The United Kingdom cannot extradite. The principle of non-devolution, what we in international law call non-refoulement, is peremptory international law. It is what we call jus cogens. Cannot be violated. United Kingdom is bound to this principle. Besides, already in 1989, in a much simpler case that did not involve an asylum seeker or a refugee with refugee status, in the case of Søring was a young man who murdered two persons in the United States, and he fled to the United Kingdom. When he was to be extradited to the United States, the lawyer submitted the case to the European Court of Human Rights and said that he wouldn't get a fair trial in the United States, that he would be exposed to the death penalty, etc., etc., etc. And the European Court of Human Rights came out with a judgment in 1989 already, 30 years ago, saying that the obligations under the European Convention on Human Rights are superior to obligations under any extradition treaty. So he could not be extradited to the United States because he would face the death penalty and what is termed the death row phenomenon, that he would face torture. Now, this case, we're dealing not with a murderer, we're dealing with a journalist whose rights are protected under the European Convention on Human Rights. We're dealing with a journalist whose rights are protected under Article 19 of the International Covenant on Civil and Political Rights. Against him are only so-called political offenses. Someone who is accused of political offenses cannot be extradited. That is ancient refugee law, ancient asylum law. And that doesn't mean that the United Kingdom wouldn't do it. The Home Secretary has actually signed it. Now it goes to the courts. There's supposed to be a hearing today at Belmarsh, what we would like to call the British Gitmo, the British Guantanamo. In any event, it will go the various stages in the British legal system. If I were a judge, I would immediately throw it out as frivolous and vexatious. I mean, obviously, non-refoulement is such an important principle of international law that it takes precedence over everything else. So if I were a judge, I would just simply dismiss the case and say he cannot be extradited, period. But if he says that he can be extradited, because, I mean, we're dealing here with what we term lawfare, the misuse of the law for purposes of politics, for purposes of injustice. The United Kingdom is under pressure from the United States. The United Kingdom wants to cooperate with the United States, and then it will simply violate its own law, and it will violate international law. But that will go then to the House of Lords. And the House of Lords, we have the precedent of the Pinochet case. The House of Lords tend to observe international law more than the House of Commons. So we will see what the House of Lords says. If the House of Lords were to say that extradition is possible, then it goes to the European Court of Human Rights. And the European Court of Human Rights would have a tough time saying that he can't be extradited. Because we know that he's not going to get a fair trial in the United States. And the Geneva Refugee Convention of 1951 has the definition of who is a refugee, meaning a person outside of his country of origin who has a well-founded fear of persecution for political reasons. Classical case, Assange. I mean, if the Geneva Convention means anything, it means that it applies to Assange. So it would be a frontal attack on the Geneva Convention if the United Kingdom were to say yes, or if the European Court of Human Rights were to say yes. It would also have to deal with its own jurisprudence. It did go pretty far in the Suring against United Kingdom case of 1989. I don't see them overturning or distinguishing the Suring case, because this one is a much more, shall we say, straightforward case. We're not dealing with a murderer. We're not dealing with a common crime. We're dealing with a political offense. And here again, I'd like to remind you that the working group of the United Nations, the working group on arbitrary detention, decided in a long judgment back 2016 that his detention at the time in the Ecuadorian embassy constituted arbitrary detention. And here the responsible countries were United Kingdom and Sweden. Here again, Sweden buckled down to American pressure. The frivolous case against Assange in Sweden had been dropped, and because of political pressure, it was reopened. So this again, you see, classical case of the interference with the independence of judges and lawyers. When, because of political reasons, a case that has been closed because there's nothing to it gets reopened. So here, when the working group declared this to be an arbitrary detention, I issued not one but two press releases telling the United Kingdom and Sweden, give a good example. You love to point to other countries. You love to engage in naming and shaming. And when country in the third world disregards a decision of the United Nations, you condemn that country for violating international law. Well, now you are on the dock. A working group of the United Nations has decided that the conditions on which Assange is being detained violate Article 9 of the Covenant on Civil and Political Rights. So, give a good example. Of course, they didn't. What happened is that the then Prime Minister of the United Kingdom, Cameron, dismissed the decision of the working group as being ridiculous. And Sweden similarly said it was not going to withdraw the cases against Assange. So here you see the primacy of policy, of politics over international law. More recently now, since he was expelled from the Ecuadorian embassy on the 11th of April and arrested by the United Kingdom, you had the Special Rapporteur on Summary and Arbitrary Executions, Agnes Calamard, from Columbia University, New York. You had Joe Canataci, Professor Joe Canataci, the Rapporteur on the Right to Privacy. You had David Kay saying, David Kay is the Rapporteur on Freedom of Expression, saying, watch it here. I mean, this is a dangerous attack on journalism. This man is a journalist. And what he has done is exactly what the New York Times does and the Washington Post does. If the Washington Post gets classified information, it's going to publish it. So he has not done anything that is not done regularly in the journalistic profession. So that would be a violation of Article 19 of the Covenant on Civil and Political Rights. And then, most importantly, Professor Niels Melzer, the UN Rapporteur on Torture, he has put out the most convincing and the strongest condemnation of what's going on. He has said that already Julian Assange is a victim of torture and cruel and degrading treatment. He's gone beyond that to say that it is absolutely shocking that in his entire career, I mean, Niels Melzer is a Swiss, member of the International Committee of the Red Cross, someone who's worked years as legal advisor with the International Committee of the Red Cross, who has had here the Human Rights Chair at the Graduate Institute in Geneva, etc., etc. He's a highly respected man. And he said that he's never seen anything like this. That countries that are ostensibly committed to human rights are conspiring, conniving in subjecting this individual to psychological torture, to such pressure as to destroy him. And obviously he has condemned the idea of extraditing Assange. But the story doesn't end there. I mean, there are implications for all whistleblowers. Now, why do we have whistleblowers? We have whistleblowers because we have criminal governments. We have whistleblowers because governments have no transparency and no accountability. governments commit war crimes and crimes against humanity and then have a whole system of covering it up. So it is highly important to have access to this information that our governments are suppressing. And for that reason, Julian Assange, Edward Snowden, and others must be considered human rights defenders. They are defending our right to information. This right to information is absolutely crucial for a functioning democracy. I mean, we cannot function as a democracy if our governments systematically lie to us, and they do. We need the private sector. We need individuals who have the courage to tell us what really is going on. And that must not be subject to penalties. I've been, as rapporteur, frequently I've gone down publicly, orally and in writing, on record, advocating a charter of the rights of whistleblowers, so that whistleblowers can channel the information safely, anonymously in some cases, and if they are discovered, that they have as a defense in whatever trial is attempted against them, the defense of truth, the defense that they are actually giving information that the public has a right to have and that the government has illegally suppressed. So these implications of the Assange case must be kept in mind, because